I'm Ben Meiselas from the MeidasTouch network. MAGA Republican attorney generals across various states are now targeting Fortune 100 corporations, some of America's biggest companies, and stating that they intend to take legal action against American corporations that seek to promote diversity within the corporations, that seek to promote female executives, that seek to promote diverse executives. And I had warned that I thought this is exactly what was going to happen after the United States Supreme Court. These 6 radical justices overturned decades and decades of precedent in Students versus Fair Admission versus Harvard, and the companion case involving North Carolina University, right? In that decision, the United States Supreme Court held that diversity could not be considered a factor at all in admissions processes, and that doing so would violate Title VI of the Civil Rights Act of 1964 and violate the Equal Protection Clause of the 14th Amendment, where those provisions were intended to protect minorities and to protect people who have been the victims of systemic racism. But, I said this is where they're beginning, but where they're going to target next is they're going to target corporations. And they're going to say, if you are a company that has diversity, equity, and inclusion initiatives, if you have initiatives to promote female executives, to promote diverse candidates, they are going to start filing lawsuits and targeting these corporations. And by the way, we are seeing that's exactly what these MAGA Republicans are doing in the House of Representatives, right? One of the poison pills that they've placed and voted on to include in the National Defense Authorization Act is to preclude any diversity, equity, and inclusion initiatives within the United States military. They've tied that to the National Defense Authorization Act to fund our military. Our military is comprised of almost 50% of people in our military are minorities, and it is critical for the advancement and promotion of military leadership. One, just it's doing the right thing, but two, for our troop readiness and just having a better and stronger military. Like, these things are required. But and I want to show you this letter right now from various state attorney generals from MAGA Republican states, or MAGA Republican state attorney generals. And this was a letter, more like a threat, that they sent to Fortune 100 CEOs. And again, this is why the MAGA Republican Party is not a conservative party. I mean, they are attacking corporations. Corporations realize that having a diverse workforce is critical, not just, again, because, yes, it is doing the right thing, but it also is critical for them to be competitive. To serve communities where they're in, they need to have diverse candidates. And for America to be a leader and continue to be an economic powerhouse internationally, it is critical as well. You'll recall from some of my reporting on the case, the Students versus Fair Admissions versus Harvard case, by the way, which was brought by an AstroTurf group, some guy named Edward Blum, who files all of these right-wing cases to try to eliminate diversity and try to eliminate diversity, equity, and inclusion, and eliminate anything that would promote diverse candidates. But remember who filed the amicus brief, which is a brief to the Supreme Court. It's called a friend of the court brief. The Fortune 100 companies, some of America's top corporations, told the Supreme Court, we need diverse candidates. And so at colleges, at universities, we need to make sure that diversity is a factor so that diverse students can come out of these colleges and work for us so that we can participate in an international economy and we could continue to succeed and thrive. These corporations told the Supreme Court, you're going to harm the United States economy if you prevent colleges from simply considering diversity as a factor. But in a 6-3 decision, these 6 radical right Supreme Court justices said, we don't care. We don't care. We believe that the very focus on promoting diversity as one of dozens of factors, the Supreme Court said that's racist. To promote diversity is racist and a violation of the Equal Protection Clause and a violation of the Civil Rights Act. Now, as predicted, that's being weaponized by the MAGA Republicans as they attack private corporations or corporations, some of the biggest companies in America. Here's the letter sent by the Attorney General of Kansas, the Alabama Attorney General, Arkansas Attorney General, and the Tennessee Attorney General. Dear Fortune 100 CEOs, we, the undersigned attorney generals of 13 states, and there's other attorney generals on there as well, write to remind you of your obligation as an employer under federal and state law to refrain from discriminating on the basis of race, whether under the label of diversity, equity, and inclusion or otherwise. Treating people differently because of the color of their skin, even for benign purposes, is unlawful and wrong. Companies that engage in racial discrimination should and will face serious legal consequences. So you may say, well, this letter seems, where's this headed? Well, they're talking about discrimination against white males is what this letter is about. It goes on to say, last month, the United States Supreme Court handed down a significant decision in Students versus Fair Admission versus Harvard and North Carolina. In that case, the Supreme Court struck down Harvard and the University of North Carolina's race-based admissions policies and reaffirmed, quote, the absolute equality of all citizens of the United States politically and civilly before their own laws. Notably, the court also recognized the federal civil rights statutes prohibiting private entities from engaging in race discrimination apply at least as broadly as the prohibition against race discrimination found in the Equal Protection Clause. And the court reiterated that this commitment to racial equality extends to, quote, other areas of life, such as employment and contracting. In sum, the court powerfully reinforced the principle that all racial discrimination, no matter the motivations, is invidious and unlawful. Eliminating racial discrimination means eliminating all of it. That's what the Supreme Court said. We ask that you comply with these race-neutral principles in your employment and contracting practices. Accordingly, the Supreme Court's decision should place every employer and contractor on notice of the illegality of racial quotas and race-based preferences in employment and contracting practices. As attorney generals, it is incumbent upon us to remind all entities operating within our respective jurisdictions of the binding nature of American anti-discrimination laws. If your company previously resorted to a racial preference or naked quotas to offset its bigotry, that discriminatory path is now definitively closed. Your company must overcome its underlying bias and treat all employees, all applicants, and all contractors equally without regard for race. Social mobility is essential for long-term viability of a democracy, and our leading institutions should continue to provide opportunities to underprivileged Americans. Race, though, is a poor proxy for what is fundamentally a class distinction. Responsible corporations interested in supporting underprivileged individuals and communities can find many lawful outlets to do so, but drawing crude lines based on skin color is not a lawful outlet, and it hurts more than it helps. We urge you to immediately cease any lawful race-based quotas or preferences your company has adopted for its employment and contracting practices. If you choose not to do so, know that you will be held accountable sooner rather than later for your decision to continue treating people differently because of the color of their skin, signed by 13 Republican attorney generals. And there they are. They are threatening corporations. You have the government threatening corporations for corporations hiring practices where corporations are simply trying to promote diversity, and then the Republicans now using this Supreme Court decision to say considering diversity as a factor in hiring practices is unlawful, and we are going to come after you corporations if you try to do so. And I'll give you an example of just some private entities and what they're doing. As I mentioned, like Stephen Miller files these civil rights complaints against all these companies and posts them on the website. He has this group called America First Legal that's somehow a nonprofit. Their most recent one, they filed a complaint with the EEOC against Unilever, the parent company for Ben & Jerry's. And they put out a press release. They go, as part of its initiative, the America First Legal, MAGA Republicans, is who they are, filed a federal civil rights complaint against Unilever, the parent company of Ben & Jerry's. The complaint asks the EEOC to investigate Unilever's systemic discriminatory hiring, promotion, and job training employment practices. The complaint follows others filed by the AFL against Anheuser-Busch, Hershey, Amazon, Starbucks. And then it says federal law forbids discrimination by an employer against an employee or potential employee because of an individual's race, color, religion, sex, or national origin. However, Unilever appears to have turned a blind eye to the law and is doing just that. And it shows what Unilever is trying to accomplish by its equity, diversity, and inclusion initiatives. And so Unilever stated, tackling equity, diversity, and inclusion will make society and our business stronger. We take a holistic approach that focuses on using our scale and reach to have the greatest impact, driving equity through our workplaces, equity through our brands, equity in our supply chain, equity in our communities. We've identified 4 strategic priorities in our drive for equity: gender, race and ethnicity, people with disabilities, and LGBTQ+. So it talks about all of their various policies there, enhancing accessibility of recruitment processes for job seekers, as well as recruiting talent and partners with people who have disabilities. We are prioritizing increasing representation of women in senior management, spending $2 billion annually with diverse businesses worldwide, increasing representation of diverse groups in our advertising, and focusing on initiatives like that. And that is where MAGA Republican attorney generals and groups like this MAGA Republican Stephen Miller group, they're going to attack these organizations doing just that and saying, in pursuit of this illegal gender and racial balancing, Unilever and its subordinate brands, including Ben & Jerry's, solicit racial self-classifications from their applicants. So this is where it's headed now. The Supreme Court, in its decision overturning decades of precedent, saying that you can't have diversity as a factor, that violates the Equal Protection Clause of the 14th Amendment and Title VI of the Civil Rights Act of 1964. They've opened the door also now for this to take place. So this is where they are heading, and they're doing it right now. And you see the MAGA Republican attorney generals that are doing that. Now, there's also the Supreme Court decision that they reached as well regarding the fake website business, which didn't really exist, which said that they wanted to use their free speech rights of the First Amendment to discriminate against a fake LGBTQ plus couple that just didn't exist. And the Supreme Court heard the case, even though the lower courts rejected it. The Supreme Court allowed the discrimination and this business open to the public that said, hey, it's just we have a creative thing where this wedding website business, we want to post a sign saying that LGBTQ plus people we won't do business with, and we want to promote that discrimination publicly. The Supreme Court said, under the First Amendment, you have the right to do that. So just think about this dystopian system that these MAGA Republicans are creating. And it's not both sides. It was a 6-3 decision. 6 MAGA Republicans were the ones who, or 6 right-wing Republicans, whatever you want to call them, were the ones who voted down precedent and said you can't factor in diversity. There ain't no Democrat attorney general on this list. It's all Republicans, and they're interfering with businesses. They're attacking the top corporations and sending a message to all American businesses. That's why we got to flag this and talk about it. I'm Ben Meiselas from the MeidasTouch Network. Hit subscribe. We're on our way to 1.5 million subscribers thanks to your support. Check us out at patreon.com/MeidasTouch. Wherever you get audio podcasts, subscribe to the MeidasTouch podcast and have a great day.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.